When VAT can be charged around residential properties or in residential leases, is something that comes up quite often, and people don't often understand the nature of this tax and when it should be levied or not. So, first thing that you need to remember is that in terms of the VAT Act, it specifically exempts VAT in circumstances where it's the hiring of a property as a dwelling, right? So if you're looking at a long-term residential lease where the person actually lives on the property, considers the property to be his home or their house, and the landlord is directly renting the property out to this individual or this person, then for all intents and purposes, the VAT Act will exempt that rent from VAT, meaning that it is not a vatable supply. Now, the implications of this, unfortunately, also mean that the landlord, who is potentially incurring expenses where they do have to pay VAT, unfortunately, because the supply of the property as a dwelling is not vatable, the landlord will not be able to claim input tax on any expenses that it incurs. So unfortunately, it's almost a double-edged sword. You can claim input tax. So input, for those that might not understand, is basically that portion of VAT that a person pays to a supplier of his, and they pay that VAT. Now, if that person doesn't use that supply now for another business purpose, it lands up being the end user, and the end user always carries the VAT expense. But now, if this person is now renting it out to somebody else who now has to pay them VAT, they're allowed to claim input tax on the expenses. A residential property, this is not the case. If you as a landlord own multiple properties where, for example, your company or you in your personal name own a residential property plus a commercial property, or there's mixed use or something along those lines, then input tax can only be claimed apportioned to the actual floor usage of those properties. So it has to be apportioned again. So the residential supply and anything associated with the residential supply and any expense associated with that supply, a person cannot claim input tax. A person can only claim input tax on the commercial side of things. Now, this is where it starts becoming funny. So what is a dwelling? What is commercial accommodation? So that's the one thing that we need to now factor in. What people don't understand is some forms of accommodation aren't exempt from VAT. So short-term rentals, hotels, that sort of thing. Because we're looking at it as short-term, there's a commercial element to it. So it's not considered to be a dwelling as defined in Section 12 of the VAT Act, and therefore it is a vatable supply. So that's something to bear in mind. There's a couple of rules around that and what VAT needs to be charged when, and there's a 28-day rule, but we're not going to get into that now because that's not the question. The question now is, if a landlord is renting out a property and the person that is the tenant of the property is possibly renting out that property to whatever, their employees, or they're running a business from their residential business from it, and they are getting their own tenants in. Interestingly enough, that comprises two different relationships. The relationship between the main owner and this company is one relationship, and the relationship between this company and the tenants on the ground is a completely separate relationship. And this was emphasized in the Res Publica case, where the courts found that even though this person in the middle, the intention was always to rent the property out to somebody else who might actually use it for residential purposes, the reality is as it stands at the moment, their lease, this first relationship between the owner and them, isn't for their accommodation because they're not actually living on the property. And as a company, as a juristic person, you cannot live. It's not a dwelling for you. So the courts have already said that for that first relationship is termed to be a vatable supply, meaning that the owner can actually claim input tax on their expenses. This person in the middle now rents the property out, has to pay VAT on it, and can now sublet the property possibly to employees or other people, in which case they do not charge VAT to these individuals. So there are a lot of nuances around this, but I have seen, for example, when companies want to rent out a huge block of flats because they've got people that they want to put in it to live there, that initial relationship between the owner and this first tenant, this company, is usually considered a vatable supply. The second relationship between this tenant and the subtenants would be considered exempt if used for residential purposes.